Good morning, everybody. Thank you all so much for joining us. We are going to wait until the last few people make it in from the waiting room before we jump into our content today. And I think we are almost all there. All right, we're going to get started. Thank you all again for joining us. We are happy to see you here today. I wanted to start our Q&A like we do every week, which is with some Zoom housekeeping tips, including asking everybody to stay muted unless you would like to unmute yourself to ask a question. And if you're wondering where your mute button is, it's on your Zoom toolbar. That's also where you will find your start and stop video button. It's also where you'll find the chat button, and that might actually be flashing because I just put a message into the chat. The chat is the best way to ask us questions today or ask us to clarify something that we've said. And we monitor that throughout the course of the Q&A. Typically, we'll hold new questions that appear in the chat until we've covered all of the questions that were submitted in advance. So if we don't get to your question from the chat today, please email it to info@condolaw.net. You can also send new questions, of course, that you think of during the week to that same email address. We ask that you get them to us by 4 p.m. on Monday, so it gives us the day on Tuesday to research your questions. If you missed the Q&A or if you're newer to the Q&A and you'd like to watch older episodes, you're welcome to go to our YouTube channel. The link for that's also in the chat. You'll see all of our old videos dating back to April of 2020, and you can search not the general YouTube search bar at the top, but in the channel itself. You can search our YouTube channel by topic to find videos where that particular topic has been mentioned. Obviously, if you search something really common like condo or assessment, you're going to get a lot of videos in response to that. But if you search something a little bit more specific, such as perhaps audit or competitive bidding or whatever, those will return fewer results that might be more relevant to what it is that you're researching. Every week we remind you, and I'm going to remind you again, that we are not here to give you legal advice. We can't do that. The only people we can do that for is our clients, where we have a fee agreement in place, an attorney-client relationship established, essentially, where we understand their specific governing statute, their governing documents, and their circumstances. So number one, you cannot send us questions hoping to get legal advice from us because we don't do that here. And number two, if somebody sends you our Q&A and says that you can't do something or you have to do something because of something that they heard in this Q&A session, you can ignore that. Just like you can ignore it if they send you our blog or some LinkedIn post or whatever. Those are not forums in which we can give legal advice. If you need legal advice, you should contact your association attorney, or if you're not an association board member and you're a homeowner, you can hire an attorney to give you legal advice as to your rights as an individual homeowner. And if you as an association don't have an attorney yet because you've never needed one, this is going to be my sort of periodic plug that you should get one. Hire an association attorney when you are not in crisis so that you can take the time to interview a couple of law firms, make sure you find one that's a good fit for your community, and establish that relationship now so that you're not left scrambling. You know, if you get a demand letter from somebody that gives you a 10-day deadline and you don't even have an attorney, it just puts you in a tough spot when those things happen. Just a quick reminder, like I said earlier, the chat is for asking questions and requesting clarification, not for discussion like you might see on the CAI message boards. Also, nothing you see in the chat is legal advice. And we have also been reminding you guys each week that the Corporate Transparency Act is still being challenged by national CAI, in addition to the fact that a circuit court in a different, a district court, sorry, in a different circuit has held that it's unconstitutional. That is going to be appealed. We don't know the outcome of that. We may not before the end of the year, but we do think that it's reasonable for communities to decide to wait until later this year before taking steps to comply, just in case the date of implementation is delayed, which is the effort that CAI is currently working pretty hard on at the national level. The last sort of general announcement is that we wanted to remind everybody that the WUCIOA for All bill that we've been talking about so much since this last legislative session, it also made changes. Part of the bill made changes to WUCIOA itself, and those changes, most of them, will take effect on June 6th of this year. We're working on a summary of those changes, and we will be discussing some of the more relevant changes in the coming weeks. These changes only affect communities currently governed by WUCIOA, right? So if you're not a WUCIOA community yet, it'll be informative for you to hear about these changes, but they won't directly affect your community until or unless you have adopted WUCIOA as your governing statute. But they're still relevant to communities that are governed by WUCIOA, and there are quite a few of those since the statute's been in effect for 6 years now. Some of the changes, for example, are to the insurance sections. Another section that's affected slightly is the records section. So Ken was joking beforehand that we had all 4 of the statutes had matching records sections for like 10 months. And now WUCIOA is going to be slightly different when those changes take effect. But again, that only affects you if you're governed by WUCIOA. For those communities that are, or for those managers that work with communities that are governed by all of those statutes, we will definitely be talking about that in the coming weeks once we have a better understanding of all those changes. Jen, did you have anything you wanted to say before we jump into the questions?
No.
Okay. All right. So here is, so our first question was actually one big, long conglomerate question with lots of different subtopics. So we're going to break it up. And the first section is, can you explain how delinquencies turn into sheriff sales? And the short answer to this question, and the part of the answer that affects how an association makes this happen, is that the board decides to take action to collect on a delinquent account, and eventually that leads to a foreclosure lawsuit to collect the delinquent amount, and the court can then authorize the sale of the property by the sheriff to satisfy the debt. So that's the really small nutshell. There are a lot of steps that you have to take before you get to that end result. And so it starts with usually having your association attorney record a lien, send a demand letter. There are also pre-foreclosure notices of delinquency, which we'll talk about a little bit more later, that are required. You have to include one of those in the first written notice of delinquency that you send to your homeowner when their account falls behind. And then you have to send another one no sooner than 60 days later, but no earlier than 90 days after the delinquency arises. So you can see there's kind of like a lot of moving parts here. You also have to meet threshold balances due before you can file a foreclosure lawsuit. And the statute currently sets that threshold balance due at $2,000. And the only thing you can consider when calculating that threshold balance due is the assessments, regular assessments, and special assessments. And you have to subtract any payments received on the account. You cannot include management admin fees, legal fees, late fees, interest charges. None of those can be included when you're calculating whether an account meets that threshold balance due. So once all of the notices have been sent, once the foreclosure threshold balance due has been met, and once the board specifically votes to proceed with a foreclosure lawsuit, because the statute does also require now that the board vote on each specific foreclosure. Before this change to the statute, we had some clients that would vote as a board and say, anytime these particular, threshold or, like circumstances are met, we pre-authorize you to file a foreclosure lawsuit. That's no longer an option. The statutes require the board to specifically vote on each foreclosure. Then we file the lawsuit. The lawsuit asks the court for a decree of foreclosure, but we also ask for a personal lawsuit, which makes garnishment an option. Once you file a foreclosure lawsuit, you can also ask the court to appoint a receiver to take control of the unit if it's not occupied by the owner. So let's say you've got a landlord owner that isn't paying their assessments, but they're collecting rent from the unit. We can have the court appoint a custodial receiver that would divert the rental income from the owner to the receiver, and that would be applied to the owner's delinquent account. If an owner contests the lawsuit, it can become quite expensive. The vast majority of the lawsuits that we file are not contested, but it certainly is possible, and it's a circumstance of which the board might, should be aware. I think it's worth noting that only a very small percentage of the foreclosure lawsuits that we file end up with a sheriff sale scheduled. And only a small percentage of the sheriff sales that get scheduled actually happen. At the end of the day, what they end up being is a really expensive way to force homeowners to deal with the delinquent account when they've been willing to ignore all other steps up to that point. And it's really unfortunate. We work really hard to try to make contact with owners and try to avoid having to file the lawsuit to begin with. But we can only control sort of one end of that two-way communication street, and sometimes that's not possible. So the sheriff's sale would happen after a judgment is filed with the court. Maybe you try garnishment and it doesn't work. The receivership isn't an option because the owner lives there. So you tell the sheriff to schedule a sale. It's an auction that takes place on the steps of the courthouse every Friday afternoon or morning at 10 o'clock. I did hear something recently that some of our counties are starting to consider virtual auctions as opposed to in-person auctions. So it'll be interesting to see if and when that happens. But that is the very long answer to the question. The short answer to the question is you've got an owner that's not paying, you start the legal process, they ignore everything else, and the board authorizes a foreclosure lawsuit, the end result of which could be a sheriff's sale. So the next part of this multi-part question was, when is it appropriate to purchase the property versus when it's not? And I'm going to start by saying that this is a really complex question, and we can't tell you when it's appropriate or when it's not appropriate for the association to purchase the property. That's a question that you need to ask your association attorney, and you're going to get a different answer in each case because the facts are different from case to case. As a general matter, it is different. There's a difference between purchasing the property with money that the association brings to the sale versus the property like reverting to the association as a result of the owner's debt to the association. That latter, the reverting thing, happens fairly frequently by default if nobody else comes to the auction to bid on the property. Rarely, I have had associations where they choose to take additional certified funds and they authorize either a board member or maybe the attorney to attend the auction and bid against other bidders up to a certain amount that the board has pre-authorized to purchase the unit, as opposed to letting it be purchased by a third party. But again, the decision to do that is very, very fact specific. And part of the analysis depends on how much equity, if any, there is in the unit, as well as whether there are other liabilities for the property. Is there a past due tax bill? Is there a delinquent mortgage situation? We've had a couple of foreclosures in the last, year. I've had two where there was no mortgage against the unit. So, the facts vary pretty wildly. So again, discuss this with your association attorney. The one other thing that I would like to point out is that starting in January of 2025, WUCIOA will ban board members and their close relatives from bidding personally at an association sheriff sale to purchase a unit. And in 2028, of course, that statute is going to apply to everyone. So I want to point out the distinction between the association ending up as the purchaser of the unit versus an individual board member bidding on a unit, that the association is foreclosing on. And so that is going to be prohibited for WUCIOA communities in January of 2025, for everybody in January of 2028. It looks like there's a follow-up question. After meeting the threshold criteria, does the lien amount include interest, late fees, and attorney's fees? Or are they a separate ask? How does the association recover them? It does include that. The lien that you record, the demand letters that we send, the judgment amount that we ask for from the court, and the judgment amount that we're ultimately foreclosing on or trying to satisfy via the sheriff's sale includes all of those amounts. Late fees, interest charges, reasonable attorney's fees and costs, management charges, again, as long as they're reasonable, fines, even if there are violation fines on the account. So the only calculation that excludes all those other categories of charges is just whether you meet the threshold balance due required to file a foreclosure lawsuit. So that's the only time that we take out all of those other types of charges and just look at assessments minus payments. I also think it's worth mentioning that if a balance due, I've got files in my office right now, and I just sent an email on one yesterday where the balance due is like $6,700, but the threshold balance due for the purposes of calculating foreclosure eligibility is like $1,000. So this one is not going to be eligible for foreclosure for quite a long time. There are still all kinds of other options that an association can pursue to collect on that debt, including a personal lawsuit or a small claims lawsuit. It's just that you can't file a foreclosure lawsuit. And when you're pursuing payment of the debt using those other methods, again, it includes all of the charges that are excluded for that threshold balance due calculation. So there's another part of the question. Why sometimes do you end up spending more on legal and taxes, which doesn't make it worth it because you won't actually recover the past due assessments? I've seen a few delinquencies that the board wasn't able to recover even after long legal battles. So every file is different, and your association attorney should be helping you through the cost benefit analysis of these files at each step where you're making a decision about if and how to move forward. However, I would like to point out that as amazing as your association attorney might be, we are not predictors of the future. We do not have a crystal ball, and we cannot predict or guarantee the outcome of any particular file. So I think it's really important to note that. Now, I can't speak to the industry as a whole, what other law firms are doing with their files, because we just don't have that information. But I can tell you that twice in the last 10 or 12 years, we have done a really deep dive into the most recent, like 300, for example, closed files in our office. And not just the good ones. We're not cherry picking only the files where we did really good for our clients and ignoring the ones where we didn't do really good for our clients. And what we have learned in analyzing those files in those big chunks is that 90% of the time or more, we collect in full for our clients. And the definition of collecting in full for us, for the purposes of this conversation, is that we collect all of the unpaid assessments and all of the legal fees and costs that we have billed our client for that collections process. Sometimes we also collect late fees and interest. Other times we don't, because the board agrees to waive those. But that's over 90% of the time. The chances of collecting in full increase if you're a condo association. They also increase if you're proactive about the legal process. So if you send me an account that's already 2 years and $10,000 behind, I'm hamstrung, okay? My ability to collect is already compromised because of the delay on that file. So being proactive really matters. The chances of collection in full do decrease somewhat if you're an HOA versus a condo. And they decrease if you do not move the process forward as quickly as your attorney recommends. And in particular, now that we have these threshold balances due and waiting periods that are dictated by statute, we are already having to move slower because of the statutory changes. So I would say it's even more important now that if your attorney is telling you, like, we need to strike while the iron is hot, we should move forward with this, that you should listen. It is true that there is sometimes a combination of factors that result in a $0 recovery. So these things would include if the owner passes away, if there's a bank foreclosure, or if somebody files bankruptcy. Some combination of one or more of those can result in, $0 recovered. That happens less than 5% of the time for the files in our office. But again, we can't predict which ones that is going to happen with. I think, though, if you look at the big picture and these numbers and sort of statistics that I'm telling you, it's relatively clear that most of the time the process will result in collection in full, even if it takes a long time. The person who submitted this question also asked for a quick refresher on how bankruptcy affects delinquencies. I want to say that as a starting point, if somebody files for bankruptcy, there's an automatic court order that just magically springs into being. It's called an automatic stay, which requires all collection action to stop. So that means once an owner files bankruptcy, you can't send delinquency notices, you can't record a lien, you can't send a demand letter, you can't file a lawsuit until you participate in the bankruptcy and figure out if and how the bankruptcy is going to affect your rights as an association long term. The delinquent assessments they end up being part of the bankruptcy estate that the court is going to review and make decisions on as far as whether a discharge is a possibility or what might end up happening. For association purposes, there are two primary types of consumer bankruptcies, Chapter 7 and Chapter 13. In a Chapter 7, the vast majority of the time, the debtor is going to surrender their property to the bank. They're going to receive a discharge of their personal liability for the balance due as of the date they filed the bankruptcy. The association still retains a lien against the property in the full amount due. The lien balance is not affected by the discharge of personal liability. So that's news to a lot of people. And once the discharge is entered and the case is closed, then it's like it never happened, except for, of course, the discharge of personal liability. But it's like it never happened in terms of your right as an association to then record a lien, send a demand letter for the post-filing balance due, or even foreclose on the full balance due of the lien. Chapter 13 bankruptcy, sometimes people call that a save the house bankruptcy. And so as you might imagine, more often with a Chapter 13, people are intending to keep their house and they're filing Chapter 13 bankruptcy essentially to allow them up to 5 years, 60 months of payment plans to bring all of their debts current. And in that type of bankruptcy, what happens is we would appear for the association. We file what's called a proof of claim that tells the court how much the owner owed the association as of the date of filing. And that also informs the court about the ongoing obligation to pay assessments even after filing. And once the Chapter 13 repayment plan is confirmed by the court, the owner makes payments to the bankruptcy trustee, and then the bankruptcy trustee distributes money to all of the creditors that are entitled to recover as part of the bankruptcy, including the association. So usually when somebody files a Chapter 13, it ends up resulting in payment in full to the association, unless the bankruptcy is dismissed for some reason before the plan is completed. I think what I would say, if you couldn't remember anything that I said about bankruptcy except for one thing, what I would tell you is this. If an owner files bankruptcy and you get notice of it, consult with your association attorney about what to do, even if there is no delinquency at the time they filed bankruptcy. Because there are deadlines and filing requirements in these bankruptcy cases that you will end up missing if you don't bring your attorney in to at least look at the bankruptcy and advise you of the situation. There's information that you would lose the ability, or not lose the ability to understand, but that you would get late, essentially, if you don't have your association attorney review the bankruptcy. For example, if the owner says, I'm moving out of the house, the bank has already told me they're going to foreclose, I'm going to do a deed in lieu of foreclosure. That's information you would want to have as soon as you could get it, and you won't get that information until you have your association attorney review the bankruptcy. So that's the biggest thing that I would say with bankruptcy is anytime an owner files, ask your attorney to look at it so they can tell you what to do, if anything. So I think we have one more follow-up question on this topic in the chat. If a unit owner pays a portion of the delinquent amount owed, and the original delinquent amount included late fees and attorney's fees, how should the association determine what portion of the balance is associated with late fees and attorney's fees in the event the association wants to pursue foreclosure? I think the short answer to this question is you can't apply the payments in a way that allows you to escape the calculation that's required by the statute when it comes to the foreclosure threshold balance due. So let's say an owner stopped paying their assessments 2 years ago and they owe you $10,000 now, and 5,000 of that is assessments and 5,000 is, late fees, interest charges, and legal fees. If they make a $5,000 payment, even if your governing documents normally allow for payments to be applied in a different way, the statute says you have $5,000 in assessments and $5,000 in payments. So for the threshold balance due purposes, you have a 0 threshold balance due and you can't foreclose. That doesn't mean that you can't normally apply payments in whatever manner is required by your governing documents. But for the purposes of the threshold balance due calculation required by the statute, you would no longer be able to foreclose under the facts that I just covered. If you have specific questions about an account where you're dealing with something like this, those are perfect questions for you to lob to your association attorney, and they'll be able to answer those for you. So I just spent, I think, 15 minutes talking about delinquencies and foreclosures. So I think I'm going to let Jennifer talk for a couple minutes. Over to you, Jennifer.
Yeah, this one's actually pretty short, so you're on again in just a moment.
Okay.
So the next question is, does RCW 6438-120 sub 7 sub A sub B refer to all tenants or owners of homes who have leased the lot under their home? So what this particular statute refers to is the particular provision in the voting statute that was changed for all common interest communities. And it says something about for instances where tenants have a right to vote. And for purposes of our particular forum, this doesn't happen. We spoke with Ken earlier this morning, and Ken has never seen a declaration require tenants to vote for anything. This is probably or is more likely to refer to long-term non-residential or business communities, such as if someone has, I think the example Ken used was a Walgreens with a 25-year lease. It's possible that those particular governing documents for that association would allow tenants to vote. But for purposes of a residential community that we normally deal with, this isn't anything that you're going to need to worry about. Did you have anything to add, Valerie?
Nope, I think you covered it. All right, our next question. I'm confused about the timing for notices of delinquency, the statutory notices of delinquency. Is an HOA required to send the first NOD when unpaid assessments equal $2,000 or more, or when a homeowner is assessed the first late fee, no matter what the amount of the unpaid assessment? The wording in the notice seems strange for a scenario where the owner is only behind by $250 or another small amount. I'm going to start by saying that I paraphrased this question dramatically because it was really long. I want to remind everybody that all of the governing statutes, all of the common interest statutes were amended first in 2020, I think 2021, and then more recently in 2023, such that now every association is required to send homeowners 2 copies of the pre-foreclosure notice of delinquency that is dictated by the statute, okay? The $2,000 threshold has nothing to do with the NOD. That is a threshold that has to be met before the association can file a foreclosure lawsuit. The steps that are required to comply with the statute when it comes to the notices of delinquency are as follows. The first time that you send the owner a written notice of their delinquency, whether it's a statement, it's a delinquency letter, whatever it is, you have to include a copy of the statutory NOD. Sorry, NOD, notice of delinquency, that's the shorthand I'm using for today. Then, no sooner than 60 days later, but also no earlier than 90 days after the account fell behind, you have to send them a second copy of the statutory NOD. And we've had clients ask questions like, what if we know we're never going to foreclose? Do we still have to send these? And the answer to that question is yes, you still have to send them. You have to send them even if the balance due is too low to allow for a foreclosure, even if you as a board will never vote to foreclose. It's a statutory requirement, so you have to do it, full stop, period, okay? Right now, the statutes allow your association attorney to send these notices if you as an association fail to do so. But the reason that the legislature was willing to put that provision in there is because we advocated really heavily, understanding that there are lots of small self-managed associations out there that don't even know about these statutory changes when they happen. And the legislature was very reluctant, but agreed to include the provision that if the HOA fails to send it, the association attorney can do it for you. That is really different. I didn't know, and therefore my attorney did it for me, is really different than I knew about this requirement. I thought it was dumb, and so I decided not to comply. And I don't want to be the one standing in front of a judge trying to explain why my client was aware of a statutory requirement and chose to ignore it. So even if you don't intend to foreclose, even if the account doesn't qualify for foreclosure, send it anyways. And if it helps to know this, the rationale behind this requirement, in particular, the new requirement from 2023 that you include a copy with the first written notice of delinquency, is to get these foreclosure prevention resources into the hands of homeowners as soon as possible, sooner rather than later. And I think it's worth mentioning that these resources will help them, not just if they're behind in their homeowners assessments, but also if they're behind on their property taxes or their mortgage. Another thing that a lot of community associations are not aware of is that Washington currently has a homeowner assistance fund, or HAF grant program, that is paying up to $60,000 per homeowner to help owners pay off their past due property taxes, mortgage payments, and assessment accounts. And this is a huge benefit, not just to the individual homeowner, which is great, but also to the associations where they live. We've had probably, I don't know, 24 communities in the last year that have been paid in full because we made the owner aware of the HAF grant program, and the owner applied, qualified for the grant, and HAF paid off their assessment balance to their association. And that can't happen if you're not sending them the notice of delinquency, because that's where they get that information. So I think that answers the question. If you have follow-up questions about this topic, you can put them into the chat, and I'm going to hand the baton back to you, Jennifer.
Okay, next question. Is a normal delinquency notice different from a first notice of delinquency? The answer is yes. So a normal, and normal in quotations, notice of delinquency is just the association's written notification to the owner that they're delinquent in assessments. The language for that particular notice is not dictated by statute, but the pre-foreclosure notice of delinquency required by statute to go out with that first notice of delinquency is dictated by statute and must be included with your normal notice. So if you only have a one-page notice of delinquency that you're sending to the owner, you have to add a second page with the language dictated by statute. It's not one or the other, it must be both. Valerie, did you have something to add to that?
Yeah, the one thing I'll add is if you're confused about what this statutory notice of delinquency, pre-foreclosure notice of delinquency needs to look like, your association attorney can prepare one for you. We include one with every collection policy that we draft. And a lot of our clients also pay us a couple times a year to update the notice, because the statute requires that the association ensure that the toll-free phone numbers and websites on the notice are current. And in order to do that, you have to go to the State Department of Commerce website. It's not the most intuitive or easy to find information. So we charge our clients $50 to update the NOD, just to make sure that they've always got a valid NOD that they can include with their delinquency notices. The other thing that I will say is, some of our clients, because they don't want to have to do the 30 days, 60 days, 90 days, like figure out when and the spacing of these notices, some of our clients have just started including a copy of the statutory NOD in every single delinquency letter and statement that they send to their homeowners. And I think that's a great idea. It takes the guesswork out of it in terms of figuring out when you have to send the first one and how long you have to wait and all of that stuff. So if that is easier for your community, I think that's a totally valid option, and it does take the guesswork out of the timing of everything. Our next question, somewhat related to delinquencies. Under what circumstance should the board consider writing off an overdue account? And what legal actions should the board take before considering this option to protect the association's interests? So I'm going to start with the second part first, and I'm going to say that this is a very fact-specific situation. So you should be consulting your association attorney for specific advice on any delinquencies you might be considering writing off. And you should talk with your accountant as well. So, the second part of the question is, what should we consider? What legal actions should we take before considering this option? Talk to your attorney, talk to your accountant. The other thing that you can do is you can adopt a policy, an internal policy about writing off bad debt. And you should be able to consult with your association attorney to draft that policy for you. They're relatively straightforward. On to the first question about when you should consider writing off an overdue account. I think for clarification purposes, I want to make it clear that writing off debt is an accounting decision, not a collections decision. So you can write off debt without abandoning efforts to collect it. Writing off debt, when I say that it's an accounting decision, when somebody owes the association a debt, that appears as an asset on your balance sheet. And we, especially back during the recession in the early 2000s, had a lot of clients that had never written off bad debt before. And so they were carrying debts on their balance sheet that were years old, uncollectible because of bankruptcy discharge, uncollectible because of the statute of limitations, debt that was owed by former owners where the unit had been sold 2 or 3 times since that debt had accrued. And if you never write off debt that you are less likely to collect, your balance sheet gets further and further and further out of step with your actual financial picture as an association. And you want your balance sheet to accurately reflect the financial situation of the association. And carrying old debts that are unlikely to be collected just skews that financial picture. As to when you write off debt, I think you write it off when the likelihood of recovery is poor, or you know you're not going to recover, or when the CPA or the bank tells you to do it. There are factors that we tell our clients to look at when making a decision about writing off bad debt. One would be the age of the debt. One would be whether it is barred by the statute of limitations. Has the debt been wiped out by a bankruptcy? Has there been a bank foreclosure? Has the unit been sold and you're now dealing with a former owner? Does the owner have a job? Do they have income? Or are they retired and on a fixed income, which is not subject to garnishment? Is there equity in the unit if you're dealing with a current owner? How large is the debt? So you can see that there's a lot of factors that you would consider, which I think supports my original statement that this is a very fact-specific question that you would want to consult your CPA and your attorney on before you make the decision. But I do think that it's important for a board to be proactive. And I think if you're just looking for like a quick and dirty recommendation, I would say look at your balance sheet. And if you're carrying debts that haven't been written off, that are either older than either 3 years if you're a condo or 6 years if you're an HOA, and they're for former owners, without knowing anything else about your situation. So you can't take this as advice, but those are ones I would look really closely at as to whether it might be time to write those off. I think I'm done with that one. Jen, did you have anything you wanted to add?
I don't. So the next question is there a statute regarding whether or not a homeowner's right to use the common areas amenities automatically transfers to tenants? No, there's no statute governing this. However, most governing documents state that use of common elements or amenities transfers to a tenant on in the rental. And this typically depends on the amenity. We typically say that an owner can use them or a tenant can use them, but not both. And this is for amenities, not for just general common areas being on the property. There's a major difference there. Next part of this question, does there need to be anything in the declaration to allow this? Not necessarily. If the declaration says it, then the declaration says it. It doesn't necessarily need to be in there. It's just a good rule of thumb that if a unit or lot is rented, typically the tenant has use of the amenities. Next part, the last part of this particular question, if rights transfer to tenants, can the association prohibit tenants from renting facilities due to the risk of damage without recourse of a possible lien against their property? This part of the question is more nuanced. And the reason why I'm saying that is that when you're prohibiting someone from using amenities that are open to other residents, you may run afoul of the Fair Housing Act. And also, that's not a rule or some other provision stating that tenants can't do something that owners can is not particularly something I want to be arguing in front of a judge. We have had communities put in prohibitions in their declaration or rules that tenants can't have pets, but owners can. And that's something that just is very problematic, and we don't recommend doing that because you're creating a separate class of residents. And that's honestly not something we want to be arguing in front of a judge. So going back to this particular question about renting facilities, you can require owners to sign rental agreements for tenants. So the owner would be the one doing the rental, but the tenant would be the one using the rental. If the language is in your governing documents, you can hold tenants responsible for damage they cause, and the cost can be assessed to the particular lot or unit. But that language has to be in the governing documents to allow that. If the governing documents are silent, you can't. You can hold the owner responsible for the tenant's actions and lien the property, meaning the particular unit or lot. You don't lien people. You lien the property. So if you have a particular situation where a tenant has rented a facility and they just trashed it, as long as you have the language in the governing documents making tenants as liable as owners for damage to property, you can assess potentially the cost of damage to the unit or lot. The owner would be aware of it, and it can become a lien against the unit or lot. If you have this particular situation, please contact your association attorney so they can walk you through the analysis and let you know what you can and can't do. Valerie, did you have something to add to that?
Yeah, I will offer that there's often a process you have to follow, giving the owner notice and an opportunity to be heard, due process, before you can assess these types of costs to their account. So you want to make sure your attorney walks you through not just whether you have the authority to charge to the unit, but how you have to do that, because process matters. And if you do it wrong and then come to us a year and a half later to try to collect it, it just makes that whole situation precarious, and we may be unable to take steps to collect it if you didn't do things correctly. The other thing is, I was looking at the wording of the question again. If rights transfer to tenants, can the association prohibit tenants from renting facilities due to the risk of damages without the recourse of a possible lien against their property? Jennifer is right. You lien the property. It doesn't have to be the tenant's property, right? And so either your documents allow you to charge these types of damage costs to the unit, in which case you have that right, whether it's an owner or their tenant that damages it, or your documents don't allow you to, in which case you can't, and it doesn't matter if it was the tenant or the owner that caused the damage, right? I have a lot of concerns about the way this whole question was written, because it reads to me like a community trying to exclude tenants from the full use of the property that they're renting from the owner. And I think that would be a difficult argument to make successfully in front of a judge, in particular because of what I just said. Either you have the right to charge this or you don't have the right to charge it. And that's true regardless of who does the damages, because most documents make the unit owner responsible for whatever their invitees and tenants do. So I think you want to be really careful in your approach to treating tenants as a different class of resident.
I have the next question, so I'm going to jump onto that. Should reviewing of bids be done in executive session to compare prices and products, and the final vote be done back in the open meeting? This is going to be a several part question because there's different parts here. So this particular part of it, the answer is it depends. The exception for, okay, let me back up. The requirement for open meetings is only found currently in the HOA Act and RCW 6490 WUCIOA. So the exception for contracts or commercial transactions is not present in 6438, the HOA Act. So there's no exception for reviewing commercial contracts or bids in executive session for HOAs. So if you're doing that, you actually shouldn't and can't, because you don't have that exception. It's only found in 6490, 445, sub 2, sub B. So just in general, if you have a practice, so for condos, of having open meetings, we would consider it appropriate to review and discuss bids in executive session and then vote on accepting which bid in the open meeting. Next part of this question, to be transparent, is it better to review and discuss an open meeting? You can do this, especially if bids are to be decided at the meeting. And this really depends on the type of bid, whether you have consultants or attorneys advising as well. So factors to consider would be amount of the project, the number of bids that you're reviewing, likelihood of an owner or someone else in the community discussing a bid or provisions of bids with the vendors in question or a completely different vendor. Do you have specifications that are present for every bid? Do you have a consultant? That's something else that you should be reviewing as well. So next part, should names of vendors be redacted on any meeting agenda attachments? Under the record statutes, and this is for all common interest communities, bids or contracts currently being negotiated are exempt from disclosure. So if you are reviewing current bids to determine which vendor you're going to use, you don't have to disclose those, and they probably shouldn't be included in agenda attachments that are available to all owners. Available to the board is a different, completely different thing. So when these bids are required to be disclosed, which is once the board decides on a particular vendor to use, then all of the bids for that particular project become disclosable, and redacting is probably not appropriate. And then the last part of this question is should the board supply a spreadsheet recap of the actual vendor bid? If you want to take the time, you can, once the bid is decided, because before that, it's not disclosable. Ken's note here is we like spreadsheets for comparison and analysis, but they are not a substitute for the actual bids or contract documents. So once the bid or contract is decided, they become disclosable and are records of the association. Before that, only the board should see them. Valerie, did you have anything to add?
Nope, I think you covered it. I'm going to jump into our next question. My accounting system now provides an AI for use by my condo clients through the portal website. It will access their account info and any public data the HOA makes available to answer questions. My question is, what constitutes public data in this sense for an HOA? Aside from recorded governing documents, what about rules, financial summaries, not complete financials, and particularly what about minutes? Only HOA members will have access to the AI. However, allowing the AI itself to access the association's private records may cause data security issues, like don't put personal information into ChatGPT. What do you think? I think that it is currently really difficult to evaluate the risk and any potential benefit from the use of AI as described. And I also think that I would be remiss if I did not say that we are not data privacy attorneys, and we're not, sort of like electronic or software attorneys. And so if you really need advice on this, I would want you to consult with somebody that has that expertise. I think, we all know that AI use is becoming more widespread. And so I'm not surprised that your software has added this function. I mean, we get these AI pop-ups now when we're using Zoom every time we do a meeting like this. I think one thing you could do, because ultimately what what this question really comes down to is what is reasonable for the association to do in utilizing this AI function within the accounting software, right? Because an association's actions are always evaluated against the yardstick of whether it was reasonable. And I think using the record statute as guidance would give an association a very strong argument that it acted reasonably. So governing documents, which would include, of course, your declaration, your bylaws, your rules and regulations, any policies to be enforced against the owners, etc., those could be public. Association meetings are not public by default, but they are an association record that should be disclosed to owners upon request. I would want to look at things like what guarantees or what type of security does the accounting software company offer or give to its users before I entered into usage of this type of AI product. The other thing you could do is check with your insurance company to see if they have any feedback for you on the utility and the risk and benefit of using AI in this context. And in particular, if your management company or your association has cyber insurance, I would really want to run this by them before I started to use it. I think, like I said, and going back to the record statute feedback, there are classifications of information and records that are very clearly protected from disclosure by the record statutes. And I would want to ensure that all of those were excluded from access by this sort of AI function within the software. But again, this is definitely a little bit outside of our expertise. I think using the statute as a guide, because that's really good evidence that the association is acting reasonably, is a good approach. And if you want really, really specific advice on this, I would want you to look for somebody that was like a data privacy attorney. But I would also really recommend you check with your insurance company. Jen, did you want to add anything to that?
No, I think you covered it. So the next question is, could you change the governing documents of an SHA to accept Airbnb? I'm not sure what SHA means in this context. We're assuming it means a single family homeowner association. So under that kind of umbrella, most governing documents can be amended to add or remove restrictions on rentals, so they could be amended to accept. The issue that has been in front of the courts most often is when the association amends the governing documents to restrict or prohibit particular things instead of allowing their use. You would need to contact the association's attorney for specific information. How the documents are amended matters. So if you already have a provision in the governing document saying you can only have rentals, all rentals must be 30 days or more. How the document is amended to keep that particular requirement, but also allow use on websites like Airbnb, VRBO, etc., really is fact specific and dependent on how the governing documents are written. So please contact your association attorney before you start trying to draft something on your own. This is one of those areas where getting advice before you do something can prevent lawsuits and having to expend much more money after the fact to fix something that you didn't expect. So Valerie, did you have anything to add to that?
Nope.
And I have the next question I'm going to try and cover fairly quickly. This one's another multi-parter, but it's fairly specific. For childcare businesses and HOAs, Condominium Law Group indicated that prior to WUCIOA coming into full effect, an association can set up some requirements, limitations in their declarations or bylaws. Codes require some businesses to have dedicated parking for employees or customers. We discovered this when an owner ran a roofing company from their unit. Has CLG come across any similar code restrictions, and how are you advising clients? So the particular statutes for childcare businesses in associations, these apply to every community, not just HOAs. So thank you, Valerie. Valerie put the citations in the chat. We have not seen restrictions like you mentioned for adult family homes or childcare facilities. If you put a restriction like this in your bylaws or declaration, we don't believe it's enforceable because the statute would override it. So next part of this question, if a declaration does not allow assigned street parking, can the declaration require that employee or customer parking is not allowed? This would be applicable to any business. Now, we read this particular question to be kind of a try to prohibit a childcare business in an HOA without actually coming out and saying that. So this is another one where we're going to go, we don't want to make this argument to a judge. If you have public streets within your community, you can only regulate behavior by your residents and by the owners. You cannot regulate behavior or parking for visitors or just people coming through. So the answer to that particular question, if you can make rules or put in the declaration that employee and customer parking is prohibited, the answer is it really depends. If you're trying to regulate childcare or group homes, the answer is probably not. The legislature is extremely specific in the statutes as to what restrictions can be put in place on these particular businesses. If the declaration allows the board to regulate common area parking, restrictions on employee and customer parking may be possible for common area spaces. This particular question is too fact specific to answer in this forum. This is one of those, just because you can doesn't mean you should. And we do not recommend going into this area and adding restrictions that aren't present in the statutes. Valerie, did you have anything to add to that?
No, I think you summed it up perfectly. I'm going to jump into our next question. When an HOA has closed board meetings, is a board still required to provide access to hearing the meetings? So when we were doing our prep, Jennifer's first bullet point says, insert rant regarding closed meetings. And I just had to chuckle because we covered this topic so many times, but I will back up and try to stay calm and remind everybody that by statute, if you're in an HOA Act association or a WUCIOA community, your board meetings are required to be opened. If you are a condominium under one of the two legacy statutes, the old Condo Act or the new Condo Act, unless your governing documents require you to hold open board meetings, which some do, then you may have the ability to have closed board meetings. So if you're a condo that's allowed to have closed meetings, that means owners aren't allowed to attend or listen either. We are generally very big proponents of having open board meetings. And I think it's worth reminding everybody that in a few years, you're not going to have a choice, because on January 1st, 2028, WUCIOA will become the only governing statute that we're all subject to. And WUCIOA not only requires open board meetings, but it limits the types of board decisions that can be made outside of board meetings to almost none, right? So I also want to back up and say that terminology matters. I think, you know, whether your board meetings are opened or closed to the owners, executive session is one part of the meeting that your owners never have the right to listen in on. Typically, again, as we preach often, that would be, you start your board meeting, you adjourn into executive session to discuss, you know, this very small subset of topics that is appropriate for executive session. And then you reconvene in your normal board meeting to vote on any issues that you discussed in executive session. I also want to remind everybody that calling something closed or calling it a working session or having a discussion at a committee meeting does not change the nature of something being a meeting that's supposed to be open if you have an open meeting requirement in your community. That open meeting requirement extends to most committees, working sessions, etc. And again, get used to the open meeting requirement, even if you're not subject to it yet, because you will be on January 1st of 2028 when WUCIOA becomes our last statute standing. I don't think that we have time to cover our last question, so we're going to save that as starter for next week. There was a question in the chat about what wording needs to go out with the delinquency notice, and do you know the RCW? If you Google your RCW, your particular statute, so let's say you're a Condo Act community, that would be RCW 64.34. If you Google that and delinquency, it'll take you straight to the section of the Condo Act that covers delinquencies. And that includes the exact wording of the pre-foreclosure notice of delinquency. And that's true for all 4 of the governing statutes. So that takes us right to 11 o'clock. We're done for the day. If we didn't get to your question, please email it to info@condolaw.net, and we will see you guys back here next week. Thanks, everybody.